So your relationship is over. You understand that in the eyes of this court, your relationship is over. If you have contact with her while you're on probation on this court, that's going to be a violation and you could be looking up to a year in jail. You understand?
This case looks simple on the surface, but it's not. A domestic violence charge, reduced to a lesser offense, still carries serious consequences, especially when the court starts asking about behavior, control, and accountability.
Court is calling 2022 CR 1782, State of Texas versus Daniel A. Pettis. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Carlos Martinez for the defendant.
Are you Mr. Pettis?
Correct.
Showing you what's entitled Acknowledgement of Discovery. Defense, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Pettis, I'm showing you what's entitled Application for Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Right.
And did you sign it?
I did.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on the paragraph 2 of the only count on there, striking the language from the paragraph. Allegations paragraph. Column.
Striking the, I'm sorry, I didn't hear.
Striking the language from the first paragraph, Your Honor.
All right, so you're proceeding on the lesser included offense of a Class A misdemeanor?
That's correct.
All right, any objections?
None, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Right, I did.
All right, did you understand the lesser included offense is an assault, bodily injury, married, or cohabitation? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to up to a $4,000 fine. Did you understand?
I understand.
If you have a plea bargain agreement with your, there's a lot of noise in the box. All right, could everyone please whisper in the box? Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I understand.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Correct.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
I understand.
And did you intend to give up those rights and enter into a plea in this case?
Correct.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Correct, I did.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, married, cohabitation. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 663004. There's an affirmative finding of family violence, and there's to be no contact with Daphne, Dafne Torres. Did you understand that to be the plea? Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
I understand.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? All right, did you understand that to be the entirety of the plea? Defense?
Yes, sir.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 1 year, and there be the BIPP program. Did you understand that was recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offense, the lesser included offense of assault, bodily injury, married, Cohabitation, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State's Exhibit 1 and all its attachments.
Defense has no objection.
All right, you can continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
As the way my client explains it, Judge, is it just situation got out of control. He's learned his lesson. He's telling me that this court or any other court would never see him again. He's got a good job now, a very good job, and he just hopes that the court would consider following the plea agreement.
All right, and I see in the police report, it has County Court 13 as a complainant. Does that have to do with the case that's being taken in consideration?
It's not out of the same incident. He drew up a protective order because of the assault.
Okay.
And
is that why they have County Court 13 in the,
right.
okay. All right, how old are you?
I'm 23.
All right, so what do you do?
I work tech support for Verizon.
Do you have any children?
No.
All right. Do you have any property with the complainant in this case?
No.
All right, so were you all living in an apartment together?
We were.
All right, so where are you living now? And when I say living, I really mean, I guess I should say, are you living by yourself now? Or are you living with someone else?
With my
All right. Any drug issues? If you're drug tested today, will it be clean? Tell me. Okay, why are you smiling? I saw a mischievous glint in the eye. So is it any marijuana or anything like that?
just like if anything, it would be marijuana, but I haven't smoked in a long time, but I know it does stay in your system for a little while, so.
Okay, you can't, I know some people, how they are about marijuana, but in Texas, marijuana is still illegal.
Right.
And while you're on probation, you're not allowed, according to the rules of probation, you're not allowed to drink alcohol at all either. You understand?
I understand. That won't be a problem.
All right, counsel, is there going to be a drug issue with your client
As far as I
that you know of?
every time he's been in my office, he's been very lucid and no signs at all.
Okay. All right. I'm going to sentence you to 1 year deferred adjudication, the BIPP program, proof of employment within 15 days. I'll know that you already have employment. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be no contact with Daphne Torres. You two are broken up.
Right.
So your relationship is over. You understand that in the eyes of this court, your relationship is over. If you decide that you want to have contact with her, you'll need to have your attorney approach the court to have this lifted. Otherwise, if you have contact with her while you're on probation on this court, that's going to be a violation and you could be looking up to a year in jail. You understand?
I understand.
All right, no contact with Daphne Torres, regular UAs. And if you can do regular UAs or either do the patch, whichever is easiest. Patch costs more money, but it's less, it interferes less on your time constraints because they just put a patch on you and tell you when to be there for them to take it off. So probation, he can either do regular UAs or the patch, regular reporting by Zoom or in person. And if you all could just do one field visit, if everything is okay after that one field visit, field visits will not be required. 80 hours of community service restitution. You can either do those hours or you can pay $7.25 per hour towards the San Antonio Food Bank. If you don't want to do it for the food bank, you can do it for any other charity of your choosing. But before you pay it, contact probation and they'll let you know if that's an appropriate charity. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Thank you.
All right. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Oh, you'll go around. Yeah. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
I understand.
All right, good luck to you. We're going to go off the record. If you decide to get into another relationship, get an Orchid. That's what I always tell people. Because orchids, when you get them from the store, they have the flowers on them when people give them to you, and then the flowers fall off. So when you get you an orchid and the flowers fall off, do not get involved in another relationship until you can get that orchid to rebloom.
Understood.
And if you do that, you'll realize that you have patience, because it takes a lot of patience with orchids. And some of them, they tell you, put them in the sun. You put them in the sun, they don't like it. Some of them say, you're moving it too much. Some of them say 3 ice cubes, which everybody that I know who's an expert says that 3 ice cube thing is just a bunch of nonsense. So that's why I always tell people to get an orchid. Not that I think this isn't serious, but I say that because orchids really do teach you to have patience. All right, good luck to you.
Appreciate that.
Oh, and the first Space Jam was better than the second one.
It really does.
I'm just gonna tell you. All right, Thank you.
Excuse me?
yes. All right, court is calling 2023 CR 4712, State of Texas versus Nancy Zavala. Can I have parties announced for the record for the state? Defense.
For the defense.
And are you Miss Zavala? Thank you so much for dressing appropriately for court. I appreciate that. All right, counsel, have you received all the discovery? Did you review it with your client?
I believe so, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you weigh the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe so, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Ms. Zavala, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 90 days in the Bexar County Jail under 1244. The state will take in consideration night mag number 691192 and 709885. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Say again, Your Honor.
Have there been any such motions?
So there is.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the plea?
Yes, Your Honor, city exhibit number one with office attachments.
No objection.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, counsel?
Not at this time, Your Honor. We request from the court that Ms. Zavala be allowed some time to get her affairs in order before she presents herself for custody.
All right, so Ms. Zavala, the person who's listed in here is the person you were in the store with. Is that the gentleman that's with you or someone else?
No, Your Honor.
All right, so why are you committing these thefts? What's your problem? What's going on in your life? Is it a drug issue? Is it a,
I just made a mistake. I'm here to accept my responsibility.
no,
I'm
but
learning on-
see, here's the problem.
Yes, sir.
I know you're here to accept your responsibility, but you're going to get to the point, if you continue on this vein, because these are state jail felonies, you're going to get to the point where you're going to end up with maybe a state jail felony as a habitual, which you'd be looking at hefty prison time. There comes a point in time where these theft cases, even though they're state jail felonies, they can be enhanced in Texas. So I'm trying to figure out, one, what are your issues? Why do you keep committing these thefts? If it's some kind of behavior that maybe can be changed, fine. If it's a drug issue, fine. If it's a mental health issue, fine. Maybe we can do something with it. But this whole thing where you're coming in, I just want to accept my time and be done with it. At some point, your time is going to be real time. So I'm trying to figure out, and I know all time is real time, but I'm trying to figure out what your problem is.
Well, Your Honor, if I may.
Yes.
She has had her issues in the past. I have spoken to her at length.
What are these
concerning,
issues?
that she didn't want. She has impulse control problems. And the part of her problem is going into a store and wanting food or what have you, and not having the wherewithal to go out and earn the money and get the food and consume that item. She has had impulse control problems, but I've talked to her at length, and I believe that she understands the gravity of the situation. And in addition, as the court has informed her, that she may end up facing significant time behind bars if she continues down this vein. And she has told me that she has realized the error of her ways and that she has actually, in her mind, reformed.
All right. So has she reformed in the past? And then, because I think, I could be wrong, and if I'm wrong, you can correct me. Sometimes people realize their issues the third, the fourth, the fifth, the sixth time. I understand that. But you have prior convictions for this. State, did the defense confer with you about having this called back for sentencing?
They asked, I said I defer to the court whether be allowed back. I did mention to the defense counsel that we would be asking that the full range of punishment would be on the table if the defendant did not show for sentencing.
All right.
Yeah, that was informed, and I was aware of that. That if the court does grant this, that the court has in the past.
All right, Ms. Zavala, is there a reason why you can't go into custody today?
Well, getting my, get my stuff like arranged, like with my boyfriend, the rent. Like let them know that I'm not gonna be paying the rent no more, like at the moment. Just, and then with my kids, well, my son, with my son, I just had a grandbaby. And I just wanna meet her, I haven't met her. And I wanna meet her. Yeah, and that's just the truth about it.
So how old is this grandchild?
She was born February 13th,
Why haven't you met her?
because they were out of town. They were out of town, so they barely came back. Or was it last week? Was it last week?
Yeah.
So your grandchild has been out of town for 5 months?
Yes, yeah. But they've been busy. They've been going back and forth to Mexico to Piedras Negras.
Mhm.
And so they've been with his wife, my son's wife. He's from over there, so they've been going back and forth, back and forth. And so he said that I can meet her this Sunday coming up at church, at the First United Pentecostal Church on Utopia Street.
All right, we're coming back on July 17th.
Oh, yes, Your Honor.
Ms. Ferguson, can you give them a reset form for July 17th?
Thank you, Your Honor.
And you understand a part of your plea bargain agreement, if you do not present yourself on July 17th, then you're subject to the full range of punishment. Do you understand?
Yes, Your Honor.
And that full range of punishment is up to 2 years in the state jail facility. Do you understand?
Yes, Your Honor.
All right, we'll see you back on the 17th. You're welcome. Ms. Ferguson will give you the reset form, then you're excused.
Thank you.
2023 CR 3033 and 2023 CR 3036, State of Texas versus Joe Vincent Vitala. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
For the defense?
Danny Callahan.
All right, and are you Mr. Vitale?
Yes, ma'am.
All right, in each cause number, you entered a plea of no contest to aggravated robbery. And each cause number, the plea bargain agreement is to be assessed at a cap of 10 years in the prison. The state opposes your application for deferred adjudication. Have both parties had a chance to review the PSI report? State,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, any objections to the PSI report? State,
No, Your Honor.
defense?
No, Your Honor.
All right, any witnesses? State,
No, Your Honor.
defense?
No, Your Honor. Allocution.
All right, state to your post?
Yes, Your Honor. Could I reserve until after the defense judge or?
No, I mean, whatever evidence you want to present to the court as to why you're opposed, and then the defense will go.
I just have argument, but Judge, we're opposed to the application for probation. The facts of the incident, like the cases that the defendant is pleading to today are knife robbery at a McDonald's, which is an inherently scary offenses, Judge. The state did take 2 of those into account, Judge, and we think the 10 years is reflected is a fair sentence for that, Judge. I know you've had an opportunity to look at a TAP evaluation, but the defendant's criminal history is on page 2, and I see a pattern, and it's escalating criminal history, starting with juvenile, moving on to misdemeanor to felonies. He also has assaultive to a couple of ABIs outside of the county, Judge. Also on page 5, the victims were of the TAP evaluation. The victims have told probation that they were scared. Of course, being threatened with magnets is a scary thing. They're seeking medical attention, some sort of counseling to help them deal with that. Also on page 7 of the TAP evaluation, I don't think I can say it any better than the victim said it. He's obviously not a good candidate for probation, Judge. Also on page 11 of the tab, towards the bottom there, he's really the defendant is minimizing his culpability. He's not recognizing that these are choices that he made. Says, I was on Xanax and methamphetamines that day, so I honestly don't remember what I was doing. This is not somebody who's taking responsibility for their actions, Judge. This is someone trying to minimize their culpability. When asked why he felt he should be granted probation, the defendant said, because I really don't want to go to prison. I'm not meant for that. Judge, this is not somebody who's taking responsibility for their actions. We're asking for the 10 years, Your Honor.
All right, defense.
Your Honor, the PSI reflects the root of these problems are threefold. He's got a mental illness, got a 7th grade education, he takes drugs. You can fix all those problems with an intensive supervised deferred adjudication and a McMild supervision. I ask that you award 10 years deferred adjudication. Moment, please, Your Honor. Nothing further, Your Honor.
All right, did you wish to say anything or no?
No, Your Honor.
Okay. All right, the court has reviewed the PSI report. I always reread the stipulations, which in this case, Mr. Vitala is the police reports and everything that was submitted to the court. And it does appear from the PSI report that you're continuing with criminal behavior. As I look at your PSI report, you had juvenile cases. And then you have cases as an adult, the discharging of a firearm, unlawfully carrying a weapon. And in those cases, you had a motion to revoke filed against you. And then we have another unlawfully carrying of a weapon in April of 2020, evading arrest or detention in September 2021. And then your felony cases, the unauthorized use of a vehicle, and then we have the aggravated robberies. And I understand when people have mental health issues, I understand when they have drug issues, but that's not an excuse, that's more medication. You understand? All right. I don't believe you'll be a good candidate for probation. So in each case, I'm going to find you guilty. Would anyone like to speak with regards to the cap? States you're asking for the 10 years?
Yes, Judge, I feel like the 10 years is an appropriate sentence based on the severity of this crime. This was a robbery with a knife, Judge. It's pretty scary. I think as the judges pointed out, as you pointed out, Judge, it's escalating behavior. So it starts as misdemeanors and then it goes up to these more and more dangerous activities, Judge.
All
I
right.
suggest to the court 6 years, Your Honor. He's no evidence that he's misbehaved in jail, that he hurt any police officers when he was arrested. He was cooperative with this court and with probation.
All right. Does anyone want to speak with regards to restitution?
Whatever the court orders, Your Honor.
Judge, the TAP evaluation indicates that there's restitution to Jathan Cantu on page 5. It's JATHYNCANTU of $120.
Defense, do you have any objection to that?
No objection.
On page 6, it's restitution to Alan Hernandez of $1,078.
Any objection?
No objection.
There's no restitution on page 7. There's no restitution amount for the other victim. The third victim is Ali Sefraoui, ALI, and then the last name is SEFRAOUI. So I just asked that the court order restitution to be determined, Judge.
All right, with regards to the restitution to be determined, the court is not going to allow that. This case has been on the docket since May, awaiting for restitution. And I find that when you say restitution to be determined, what ends up happening is somebody could say they want $30,000, and then Mr. Vitali, though he's done wrong, he won't have an attorney to address the issue of the $30,000, and somebody will just put that, and it'll take a while to clear that up.
Yes, ma'am.
All right.
Well, there's one final complaining witness, Judge, sorry, on
Mhm.
on page 8, Damian Pettis. He said that his monetary loss was $250, Judge.
Any objection?
No, Your Honor.
Mr. Vital, your attorney is telling me that you have mental health issues and that you have drug issues. If you would like, the court could recommend the therapeutic community for you. It doesn't increase the time that you spend at the prison, but they can help you if you so choose. So would you like to be considered for the therapeutic community? All right, you'll still have to ask for it though. All right, and cause number 2023 CR 3033, the court will find you guilty, sentence you to 10 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3036. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution of $120 to Jathan Cantu, restitution of $1,078 to Alan Hernandez, restitution of $250 to Damian Ortiz. And cause number 2023 CR 3036, the court will find you guilty, sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 3033. Take in consideration 2023 CR 3034, 2023 CR 3035. There's to be restitution to the following: $120 to Jathan Cantu, $1,078 to Alan Hernandez, $250 to Damian Ortiz. And in each cause number, the court will recommend the therapeutic community. Is there anything else from either side with regards to sentencing in either cause number?
No, Your Honor.
No, Your Honor.
All right, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction in each cause number, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Are there going to be victim impact or no?
No, Judge.
All right, so here's the thing. How old are you? 28. 10 years is a long time. I personally think any time that you're confined is a long time. I remember when I was a defense attorney, people would make an offer to my client and they'll say, oh, they can do 2 years standing on their head. And you know what I would always tell the person? Have you ever done time? Until you've done time, you can't say that. So I realized that every single day locked behind bars is a long time. But you're going to have to do better. I see that you have children. If you don't do better, you know what's going to end up happening? You're going to end up spending the rest of your life at the prison. You understand? So I'm giving you a chance to take advantage through the therapeutic community, and you got to do better. Otherwise, you're going to be the grandpa at the prison. Don't be that person, okay? All right, good luck to you. Could I get the dismissals?
Yes, ma'am.
Yes. No, he has 2 dismissals.
Oh.
The court denies probation and sentences him to 10 years in prison on both aggravated robbery cases. Mental health and drug issues were part of the discussion, but not enough to outweigh the violence and the escalation. The judge made it clear. This was a turning point. Now the only question is whether he uses that time to change or comes back even worse.
All right, Ms. Lockhart, we're going to bring you back on July 27th. My understanding from probation is you have an appointment with them on July 20th, okay?
Okay.
All right, so we'll bring you back on the 27th to see where we are. Yes.
One other thing, Judge, we talked about mental health.
Mhm.
Which she apparently told somebody in the system that she's not interested. She is interested in mental health work. She not discussed that today. She understands a little bit more about health work and part of your probation. And I think that's a fantastic program. And I would highly recommend that she either be pre-screened or whatever she.
Well, here's the thing. You have to discuss that with your attorney and counsel. If you want to speak with mental health court and talk to them, you can. And they will have your client with you on at that time. If you want to be there with her for the interview.
Okay, can you restate with you? Okay, so probation.
Probation is going to come visit you on July 20th because that's when you're scheduled for your next evaluation.
Okay.
And then we're going to come back on July 27th because I will have that report so I'll know what's a good placement for you.
Yes.
All right. So do you want to go to mental health court?
Not,
I mean, you can discuss it with your attorney, okay? Now, here's my other question. Why is her outfit dirty? I mean, this is not, I have dirt that just won't come out of an outfit. It's dirty. Does anybody know why her clothing is not clean? Are they not doing laundry at the jail? I mean, am I the only person seeing this, that her outfit is dirty? I mean, were you crawling on the floor or something in your outfit, or did they give that to you like that? All right, so we're gonna have to, I'll call the jail and see what's up with laundry. I mean, I know they,
yeah, I think you could switch it to too.
your sheets are dirty too?
Where are they keeping?
8.
But I mean, is it just regular? So it's GP. Thank you. So no, it's GP. So
All right, so I'll call over there and see what's going on with the laundry. I think they have the trustees to do laundry. Okay, I'm sorry.
It was making me itch.
Okay, well, here's the thing. As I tell people, when you're at the jail, you're not going to get the detergent and then they're going to put some Downy in the rinse cycle
They don't leave.
or sheets. Your detergent just says detergent. The soap just says soap. So, but I'm going to check on that at the jail. And so you're saying sheets are not being washed and the uniforms not being washed?
Yeah.
Okay, all right. I will talk to the sheriff about that.
Thank you.
And I'll talk to the sheriff about deputies being worked overtime, but that's all I can do is put that out there. All right, is there anything else?
Your Honor, if I may.
Yes.
If we're going to re-refer over to mental health court, I'll just give you an order to sign.
Yes. Okay, but that won't interfere with her scheduled 20th date.
We're gonna keep that date as well.
Okay, all right, so your attorney is going to talk to you about mental health court. So we can't do this thing where you tell them you're not interested and then we do this back and forth. We don't do that, okay? So your attorney will speak to you about that, but I will see you back here on the 27th. Yes, and I'll talk to the sheriff about the outfits and the clothing.
Thank you.
You're welcome. All right, so on May, I saw that the autopsy was completed. So where are we on this case? This has been going on since January 2023.
Yes, Judge, we received an offer today. Ms. Pettis is not accepting the offer at this time. So.
Oh.
Yes, we put, so
I'm going to give you a reset date for a plea deadline date. So in this court, Ms. Pettis, there is no, I'm not accepting the offer at this time. What ends up happening is I give you a plea deadline date. On that date, you need to let the court know whether or not you're accepting the offer. You understand? If you choose not to accept the offer, then the court will only accept a plea bargain agreement for good cause. Otherwise, you have to plead open to the court. You understand? So in this court, people are not allowed to come in on the day of jury trial and they see a jury and they say, oh, I'll take that offer now. That's not the way it works in this court. You understand? All right. So let me see. Norma, can we recall this back for July the 24th for a plea deadline date? All right. Do you understand what a plea deadline date means? All right. Do you understand what that means? Well, let me explain it to you. The state has made you an offer. I don't want to know what the offer is because your attorney is saying you're not accepting that offer. So the state has made you an offer. I'm going to give you a chance to think about it. So you're going to come back on July 24th. On that date, you're going to let the court know whether or not you are accepting the state's offer. If you choose not to accept the state's offer, then your plea deadline date will have expired. So what that means is, let's say 3 weeks from now, or you're set for jury trial. You see a jury come in and all of a sudden you lean over to your attorney and you say, I want to accept the state's offer. Court is not accepting any plea bargain agreements after July 24th without good cause. Otherwise, you have to plead open to the court. Do you understand? So the range of punishment on this case, I believe, is up to life in prison. So that would be your range if you were to plead open to the court. You understand? You have any questions? Okay. Are you not able to speak loudly enough?
She can, she was very like.
All right. No, she'll need to speak up because if I can't hear her, then
I understand.
yes. All right. So do you understand everything? Do you have any questions about anything? Oh, sure. You can speak to your attorney. We'll put you in the box and you can speak to your attorney. All right. Thank you.
It would be excused from there.
Yes.
Thank you.
Hello. Thank you for coming and thank you for dressing appropriately for court. All right. Court is calling 2023 CR 3055, State of Texas versus George Ibarra. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
For the defense?
Mr. Ibarra.
And are you Mr. Ibarra? All right, Mr. Ibarra, you entered a plea of no contest on June 20th. The court found there was sufficient evidence to find you guilty. The court found you guilty and you were reported here today for sentencing. And I appreciate that you came in knowing that you were going to be sentenced to do time. So before I sentence you, is there any drug issue on your part? Because I see this as a possession less than a gram case.
I've had issues before.
All right. So what I can do is I can refer you to the therapeutic community if you wish to be referred to the therapeutic community. It's held at the prison. It doesn't increase the length of time that you're in custody at all. Would you like that? Okay. All right. The court is finding you guilty as previously stated. The court will sentence you to 11 months in the state jail facility. Court will give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, no, that's yours for your client. And because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, Mr. Ibarra, when you get out, go do some sober support meetings. Don't get caught up in this. Otherwise, you're going to find yourself in and out of custody. You understand? And with regards to drugs, you never know if you're going to end up with a bad batch, and the last time you use may be the last time you use. You understand? All right, good luck to you. Thanks for showing up.
Thank you, Your Honor.
Right.
Excuse?
Yes.
Thank you.
Court is calling 2023 CR 1044, State of Texas versus Anthony Ray Cantu. Could I have parties announced for the record for the state?
Hank Wilkins for the state. Andrew Fraley.
Are you Mr. Cantu? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 18 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing it, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
There.
Next, I'm showing you outside the plea bargain agreement. State is asking for no contact with the complainant in this case. Did you understand that's a recommendation from the state and the court does not have to follow that recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I submit State's Exhibit 1 and attachments.
No objection, Your Honor.
All right, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, we are back on the record. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, sentence you to 18 months in the state jail facility. There's to be credit for any time served, and there's to be no contact with Leonard Hernandez.
Judge, I could, my client is 44 days and I want to make sure that you agree to give him credit for any time served. And second, any diligent participation in state jail. I'm not sure if you need a presumptive diligent participation or whether you would do that afterwards.
Oh, they'll send a form to me. If you're actively participating and availing yourself of the programs that are there to help better yourself, and hopefully you won't come back before a judge, then the court will strongly consider giving you that. And what I can tell you is I usually do give that when I see that people are taking advantage of the programs that are offered. All right.
That's what
Okay,
Thank you very much.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I'm sorry, what was your plea in this case? Was it no contest? All right. All right, and because this is a felony conviction, you're not allowed to own any weapons or ammunition. Do you understand?
Yes.
All right, we can go off the record. How old are you? You're gonna have to do better. Do you have children? Okay, that's a good thing. You got to get your life together, then start working on other things. You understand? Don't come back here. This is foolishness, okay? All right, good luck to you.
Thank you.
Whoever did your tattoos did a good job, by the way. Court is calling 2023 CR 3443, State of Texas versus Larry Everett Berry. Can I have parties announced for the record for the state?
Hank Wilkins for the state yard.
Defense?
Kenton Longacre from Mr. Barry.
Are you Mr. Berry? Counsel, have you received all the discovery and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Berry, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it and did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge, except we're waiving the enhancement.
Any objection?
Not at all, Judge.
Mr. Berry, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Certainly have, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I believe he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 16 months in the state jail facility. There's a $2,000 fine. State opposes your application, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No objection, Judge.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. This will be set for sentencing on September 7th. The reason why it's such a long date is because there's a slight backlog. Probation, I'll need a PSI and a TAP.
Your Honor, excuse me, Your Honor.
Mhm.
I'm set for trial in 144th beginning on September the 7th. Could it be another day?
Well, we'll see where we are because I don't know. It may be done sooner than that. So we'll just see where we are. We're going to keep the September 7th date. Then if you're in jury trial, then we'll move it to a different date.
Thank you, Judge.
All right. And I'm going to want a TAP evaluation. And you can do a referral to felony drug court. All right, Ms. Ferguson, we'll give you a reset form and we will see you back on the 7th. On September 7th, I'll make a decision on your application based upon the PSI report I received and any other evidence that's presented. All right,
Thank you.
thank you.
Maybe excuse.
After he signs the reset form.
Yes, ma'am.
All right. So, Mr. Jones, the court
Yes.
has received this violation report and it's with regards to your GPS.
Oh, yes, I was out at Roosevelt Park yesterday. I was there for like 20 minutes walking. And
Oh, no, he can talk. It's fine. We're not,
Make sure he wasn't cutting you off.
no, he's not. All right, you can continue.
We got a call from, I think it was, I didn't have my phone on me, but, I think we had a call from Miss Vasquez and they called out, a person from a group home to come get me. But I was out there for 20, maybe 30 minutes.
All right. So do you understand what GPS is?
I do not.
All right. So GPS, that means that you're on a monitor.
Okay,
And that means if you're going somewhere, you need to get permission.
okay, all right. I did not get permission. I did not know that. I don't think they told me.
Okay. All right. Well, this is your first violation report, and I know there are some mental health issues that are going on as well,
Yeah,
but you are not allowed to make unauthorized stops. Being on GPS in a way is sort of like being at the jail, only you're out and about.
yeah,
So you have to call and get permission. Do you understand?
yes, I do. They did not tell me that I had to do that. They said, they did say though that I had to stay at St. Mary's, but I thought, I don't know what I was thinking, actually. I don't know what I was thinking.
That's okay. Ms. Vasquez, does he need to call you to get permission to go for a walk in the park?
Judge, if that's something that you would allow, as long as he gives me 24-hour notice, I can have him out on a schedule.
Okay, yeah, that sounds.
Your Honor, with regard to that, I know that he's been out on the CHCS complement restoration for about a little over a week and a half, Judge, and it seems like he had an issue because he does like to go to the park. He also wants to try to look for a job. So that's why we filed the motion to modify to from partial to tracking only. However, if
We're not going to do tracking only.
the court does not see fit, I did also in the order allow, if the court sees fit for him to be able to go exercise in the park or look for a job from the hours of 9 to 11. He has been in custody previously 10 months, waiting competency issues. There was not a bed for him, so I reached out to Center for Healthcare Services. They stated that he didn't meet criteria for that outpatient competency restoration. But my client does suffer with some mental health issues, and he says that being in the park and being able to be out in the sun, it's vitamin D.
Well, I mean, here's the thing. He will be allowed. State, do you have any objection to him being in the park?
No, Your Honor. We would have an objection to modifying the tracking only, but if
All right,
that's
so
not an issue.
we're not going to do tracking only. Mr. Jones, are you living with someone?
I'm
Well, I'm at the 1618 St. Mary's.
Okay.
Rio boarding house, but I'm not with anybody.
Okay, so we'll do this in increments, okay? Because I have to make sure that you're following the rules.
Yeah.
And so I can't give you, well, I won't give you tracking only because we're here for a violation. So we'll start with you having a window where you're able to go to the park, but you're not allowed to make contact with the complainants. Do you understand?
Yes, I understand.
Right. So before you go to the park, for example, if you want to go out to a park on a Tuesday, let's say you want to go to the park tomorrow,
Yeah.
you need to call Ms. Vasquez and let her know, hey, I would like to go to the park on Tuesday.
Yeah.
If Ms. Vasquez says yes, she'll give you a time frame of when you're allowed to go, okay? So he'll be allowed to go to the park, but he has to call Ms. Vasquez the day before.
Okay.
All right?
Yes, Your Honor. One further thing, Your Honor, before we're done with this hearing, is that I did speak with the mother, the complaining witness in the
Mhm.
case, Stephanie Jones. She does want him to be on the GPS monitor. However, she requested that she be allowed to assist him. She, for instance, wanted to take him some hygiene products, some clothing as well. But she has a no contact order there, so she's just requesting to help. I know that at the facility too, since Mr. Jones has a lot of appointments with the Center for Healthcare Services as well as free trials. She said that she can assist, but that we need to change the no contact order. But I told her I would adjust it with the court, and she was working this morning, so unfortunately she couldn't be here. But I do have an affidavit non-prosecution as well. She more so just wants him to get the help he needs, Judge.
Mhm.
Doesn't want him embroiled in the criminal justice system for punitive purposes. But we're all, I think, on the same page, including Ms. Vasquez, which we did meet with Ms. Vasquez and Mr. Jones this past Friday, and we did get more so on the same page. And I think he is coming to understand, Judge, but he does have some lapses there.
Okay. All right. So this is what we'll do with regard to that. The next setting he has for August 17th. If you want to set this sooner than August 17th, just let the court coordinator know. We'll have him brought over and make sure that Ms. Jones is present and confer with the state. I'm sure the state will work with you.
And we'll get in contact with Ms. Jones as well.
Yes, sounds like a plan, Your Honor. I appreciate the court's time.
All right. Thank you. So do you understand, Mr. Jones?
Yes.
All right. So if you want to go to the park tomorrow, you need to call Ms. Vasquez today.
Yeah, okay.
Do you want to go to the park tomorrow?
Yes.
All right, Ms. Vasquez.
Would I be able to go to the park tomorrow? Oh,
All right, yes.
Oh, sorry, I'm mentally.
No problem. Ms. Vasquez.
Would I be able to go to the park tomorrow, Ms. Vasquez?
Yes, sir. I just need a time frame.
9 to 11.
Okay, I will go ahead and put in the schedule for tomorrow.
All right, thank you.
All right, thank you.
Thank you, Your Honor.
But here's where this case shifts. The judge sees more than just the violation. Mental health struggles, confusion about the rules, and someone trying imperfectly to do better. So instead of locking things down, the court gives him structure, a controlled window, strict rules, and one clear message. Follow the system, or the system will follow you back to jail.